see the benefit in a case like this, where the evidence is what it is, to kind of rehash it, put it out into the public sphere again.
The courtroom was silent. Not the heavy silence of respect, the tense silence of a country holding its breath. Everyone waited. Reporters, families of the victims, viewers around the world watching the live stream. Then the screen flickered on. Not a person walking into the courtroom, just a small square on a monitor. Inside it, the man accused of assassinating Charlie Kirk. His camera was off. No expression, no glimpse of his face. A voice came through the speakers. Flat, controlled. "Yes, Your Honor." 2 words. That was it. No emotion, no explanation. The defense didn't challenge the charges. They didn't argue. They asked for one thing: time. Time, while grieving families demanded answers. Time, while a shocked country demanded justice. Why the delay? What are they waiting for? And then, the judge spoke, calm, measured, but what he said next stunned everyone in the room. This is not just another case. This is a test of the system itself. You're watching Unraveled Crime. Hit subscribe, tap the bell, so you don't miss the twists in this story. Because they're only just beginning. It began like any other procedural hearing. A judge, a prosecution team, a defense table. But the stakes could not have been higher. The case: State of Utah versus Tyler James Robinson. The man accused of assassinating conservative commentator Charlie Kirk. This wasn't just another headline scrolling across a news feed. The shooting had unfolded in front of thousands of students at Utah Valley University. A routine campus event turned into chaos. Many witnessed it in real time. Some even live-streamed it. For weeks afterward, the nation argued, was it a politically motivated act, a personal vendetta, or something even darker, something no one had yet uncovered? Now, after all the speculation, the accused was finally before the court. Except he wasn't actually in the room. He appeared through a video link, a remote presence in the most publicized case in Utah's recent history.
And let's bring back Josh Ritter and Donna Rotuno now. If we have them there, let's pull them up. You know, Josh, if you're there, I want to start with you. There was some discussion about waiving the preliminary hearing. The preliminary hearing is an opportunity, as Paul Morrow said, to have a mini trial. You get evidence, you can cross-examine witnesses. It's determining probable cause. What's your analysis of the defense saying we're not waiving the preliminary hearing?
I think they want to view the evidence. I think they want to see what exactly the government has. Are they able to prove it? Another thing that happens at the prelim is it's an opportunity to see how some of these witnesses perform. So perhaps they want to see how some of these investigators perform on the stand and nail down their testimony to a specific narration and make sure that they stick to that, put in their testimony on the record. I will note that it sounds like we're going to be dealing with this case for quite some time, given that the prosecution said the discovery is voluminous. And if you think about it, this is a crime, a murder that took place in front of hundreds of eyewitnesses. All of those people have to be identified and interviewed, electronic devices. This is a process that's going to take quite some time.
Donna, on that point, we heard the voluminous discovery process mentioned by both counsels, and there is quite voluminous discovery. You've got the DNA on the weapon. That will be forensic analysis. I'm sure they will try to challenge that in whatever way they can. You have the messages on Discord where there was an admission from Tyler Robinson that he had committed the crime. You have the text messages with the roommate where he methodically talks about looking for the weapon. There's even messages beforehand saying that he had an opportunity to take out Charlie Kirk. Voluminous evidence, and I fully suspect the defense to say, have you crossed your T's and dotted your I's in the collection of this evidence?
No question. That'll be the biggest thing they'll do in terms of those pieces of evidence. Did they perform the proper subpoena power that they have? Did they obtain these documents the right way? Did they talk to the proper witnesses in order to be able to gather what they needed to gather? And so, yes, they will definitely be having to perform, showing that they've met every foundational requirement. So there's going to be a lot of picking apart, I'm sure, of every piece of evidence by the defense because they're going to try to do anything they can. Anytime you have a case where it does seem that there is a lot of evidence and voluminous discovery, the defense is going to have to try to poke holes in any way they can. And we did hear her say that she wants time to determine whether or not she's going to waive this preliminary hearing. I'm still not so sure we're going to see one, but time will tell.
And what's your analysis for why we won't see that preliminary hearing?
I just don't think that they're going to want, and I understand what Josh says in terms of trying to put people on the witness stand, see how they perform, but I do not see the benefit in a case like this where the evidence is what it is to kind of rehash it, put it out into the public sphere again. I think what the judge did in his comments was to do a very great job to say, we do not want any problem with the jury pool. We do not want to seem like we're unfair in any way. This is a way to make sure that this case does not have a change of venue request or that one is not granted. And I think in that same vein, I don't think that the defense is going to want all of this evidence to get out and potentially taint the jury pool any more than potentially they already have been with the statement that was read to us by the prosecutor right after the arrest was made.
We'll be
The
watching
heavy
it.
wooden doors opened. The judge entered. Everyone in the courtroom rose to their feet. The air was taut, silent except for the faint shuffle of reporters. Then came the rapid clicks of cameras. Flashes lit the tense faces in the gallery. The prosecution team was there in full force. Chad Grenanda, Jeff Gray, Lauren Hunt, Ryan McBride, Chris Ballard. Each wore the solemn focus of a team ready to fight for justice. Across the aisle sat the defense. Catherine Nestor, composed and sharp, flanked by Michael Burt and Richard Novak. They had prepared for the storm to come. The judge looked up, his voice carried across the courtroom. "Do we have Mr. Robinson present?" A pause, then a voice over the speaker, flat, measured, almost emotionless. "Yes, Your Honor." No camera, no face, no visible reaction. That was all the country heard from the man accused of killing Charlie Kirk. Everyone expected a fight, a fierce challenge to the evidence, a demand to move fast, bring the case to trial, but that's not what happened. When the judge asked how the defense would proceed, Catherine Nestor stood. Calm, careful. She didn't attack the evidence. She didn't question the charges. Instead, she asked for more time. She said the discovery, the trove of material collected by prosecutors, was enormous. The prosecutor himself admitted it. Voluminous, he called it. Thousands of files, digital forensics, phone logs, encrypted messages, videos from the scene, body cam footage. All of it needed to be reviewed. The defense asked to push back the preliminary hearing, the moment when the court decides if there's enough to proceed, not by a few days, by weeks, maybe months. The judge set a new date, October 30th. Both sides agreed. In the gallery, the victims' families listened in silence. For them, it was one more delay in the search for answers. Then something rare happened. Judges often keep their remarks brief, formal, neutral, but on this day the courtroom fell silent as the judge paused, his gaze sweeping across the room. When he spoke, his voice was steady, but carried a weight that commanded attention. He reminded everyone of the foundation of the justice system. Mr. Robinson sits before this court presumed innocent. That presumption remains unless and until every element of every offense charged against him is proved beyond a reasonable doubt. His words were deliberate, meant not just for the attorneys, but for the families, the public, and the cameras. He then turned to the victims' families, acknowledging their grief. He promised they would be treated with fairness, dignity, and respect. And then came the line that defined the moment. "Let me be clear. I will not put my finger on the scale of justice." It was a rare glimpse of principle and restraint, an assurance that even in a case under the nation's gaze, the court's duty was to the law above all else. Legal analysts quickly explained what the defense's request really meant. In Utah, cases like this don't automatically go before a grand jury. Instead, the preliminary hearing is the first real test. It's where the prosecution must show there's enough evidence to move forward to trial. By asking for a delay, the defense wasn't stalling for no reason. They were buying time. time to sift through thousands of pages of reports, time to examine hours of video, audio, and data, time to search for gaps, inconsistencies, anything they could use. But the delay came at a cost. Tyler Robinson would remain in custody waiting. The victims' families would keep waiting too. And the public, already gripped by the shocking crime, was left in a tense suspense, wondering what the defense might uncover. In the weeks after the arrest, more details began to emerge. News outlets reported on a series of text messages that investigators say they recovered. Messages exchanged between Tyler Robinson and his roommate. According to those reports, the texts revealed troubling conversations, discussions about planning, choosing the right spot, expressing worry about leaving fingerprints, and most chillingly, references to a rifle said to belong to his grandfather. For prosecutors, that kind of evidence suggested something clear: intent. It pointed to preparation and forethought, but the defense viewed it differently. They raised questions about context, about Robinson's mental state at the time of the messages. Some legal commentators speculated there might be an attempt at an insanity defense, but under Utah law, that bar is set high. A defendant must be unable to understand the nature of their actions or tell right from wrong. Planning, choosing a location, worrying about evidence, those details can undercut such a claim. For now, nothing is settled. The upcoming preliminary hearing, once it finally happens, will give the public its first real glimpse into how strong the prosecution's case truly is. The delay set off a wave of frustration. Online, the debate was relentless. Some demanded to know why the man accused of killing Charlie Kirk was allowed to appear by video, his camera off, his expression hidden. Others questioned the slow pace of the case. Yet there were voices defending the judge's calm insistence on fairness, reminding the public that due process protects everyone. For the families of those caught in the shooting's chaos, the debate didn't matter. For them, the delay was another painful chapter in a long, uncertain wait for justice. Their grief lingered, quiet, unresolved, and heavy. That's what makes this case so gripping. The crime itself was sudden, public, and brutally violent. It shattered a sense of safety on a college campus and stunned the country. But the legal process that follows is the opposite. It's slow, deliberate, careful. The man accused of the killing remains largely silent, speaking only in brief, controlled words. The defense asks for more time. The judge insists on remaining impartial, bound by the law. Meanwhile, the public demands answers, immediate and clear. This clash between the urgency for justice and the deliberate pace of the courts is what defines these early days, a tension between outrage and due process that will shape everything to come.
Enter your appearances, please.
Chad Grunander, Jeff Gray, Lauren Hunt, Ryan McBride, and Chris Ballard for the state, Your Honor.
Good morning, counsels.
Good morning, Your Honor. Kathy Nestor, Michael Burt, and Richard Novak on behalf of Mr. Robinson.
Good morning, Your Honor.
Good morning to you all.
Good morning.
And to the jail, do we have Mr. Robinson present?
Yes, Your Honor.
All right. Mr. Robinson, good morning to you as well. Counsel, as we begin, I have entered orders allowing the admittance of Mr. Michael Burt, Mr. Richard Novak, pro hoc vice, and appointing them along with Ms. Catherine Nestor to be Mr. Robinson's counsel. The court enters findings that the combined experience of counsel meets and exceeds the requirements of Rule 8. Counsel, do we have, what would we like to accomplish today?
I have two items, Judge. I just wanted to make a record that under Rule 16 of the Utah Rules of Criminal Procedure with respect to discovery, the state is required to provide to the defense within 5 days of the defense's request the discovery that we relied on in making this charging decision. We'll be prepared to do that, so we'll look for defense counsel's request or the next day or so, and we'll provide that to the defense.
Thank you.
We also, for the court's information, we met this morning with the defense team briefly in our office to talk about discovery and the process, so we'll be working together. There is a substantial amount of discovery in this case, Your Honor. It's voluminous, to say the least, and we're working on a process where we can exchange information as quickly as possible and be efficient in that process. The other item I had, Your Honor, I saw that over the weekend there was a protection order, pretrial and trial publicity order entered by Your Honor. And I just was seeking some clarification. On page 2, at the end of the first paragraph, it reads, "To that end, lawyers participating in the investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams that the prohibitions contained in this order." The state, we're seeking some clarification with respect to the phrase "all witnesses," Your Honor. There are a number of witnesses that have yet to be identified that will likely be used in the state's case. This occurred in front of 2,000 to 3,000 students at Utah Valley University. So we're in the process of identifying those witnesses. And so those individuals are presently unknown right now. So we're looking for a little clarification from the court. And I suppose we're not going to make any arguments today, but there may be some follow-up pleadings that we may need to file.
Thank you. Ms. Nestor, did you want to be heard about that issue?
No, Your Honor, we would defer to whatever the court wants to advise them on that matter. I mean, I think it's fairly obvious that we don't know who all the witnesses are in this case yet. I think it's just important that if anyone is identified, that they have information about this order. So I think other than that, we wouldn't weigh in on any other matter.
Thank you. Well, thank you for that question. That's an important one. The court will rule that as the witnesses become known to each side, that information is conveyed to abide by this order. Obviously, there are potentially many witnesses, and so it's not the expectation that you would be able to do that up front, but as they become known, I would ask that you would inform them of this. Anything else, counsel?
Nothing from the state, nothing else, Judge.
Thank you. Ms. Nestor.
Thank you, Your Honor. We recognize that we are here today for a waiver hearing. It is not our intent to waive a preliminary hearing in this matter. We are going to be seeking that one be set. However, based largely on what the state just referred to as far as the voluminous nature of the discovery materials, we do think it would be prudent to simply reset for another conference, another waiver hearing, a little bit down the road, where we have a better idea once we start seeing the discovery as it rolls in. I do recognize we're going to be getting that first batch in 5 days, but it's my understanding from our meeting today that there is massive amounts of digital that is going to be coming, and until we can kind of get our heads around exactly what we're dealing with and how much we need to process, it's going to be difficult for us to give you a reasonable expectation of when we will be ready to do the prelims. So we're asking today that we put that decision off, and maybe we could check in 30 to 60 days and just kind of let the court know where we're at and how much we're looking at and how much time we may need to set a preliminary hearing. Also, as far as a detention hearing, we are not asking the court to address that issue at this time. Under the statute, the issue is going to come down to the question of whether there's substantial evidence, which right now we're just not in a position at all to be able to even argue to the court. So we are probably going to ask that the court delay that decision possibly until the time of the prelim. But if it's sooner, we will ask the court for a hearing. But at this time, we are not asking the court to make any decisions on that matter.
Thank you, counsel. In regards to the next hearing date, how about October 30th at 10 a.m.?
That works for the state, Your Honor. Thank you.
All right.
That's fine for the defense, Your Honor.
All right. Now, as we're at the beginning, anything further from counsel from either side?
No, Your Honor, thank you.
No, Your Honor, thank you.
As we are at the beginning of this case, it is my intent to only speak when I'm needed or it is necessary. But today I do wish to provide guidance and expectations that you can have for this court and wish to enter an order as well. As this case moves forward, Mr. Robinson's constitutional rights will be protected at every stage. He sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. At the same time, and as applicable, victims are entitled under our Constitution to be treated with fairness, respect, and dignity, free from harassment or abuse. Justice demands that both of these principles, the rights of the accused and the rights of victims, be honored without compromise. I remain steadfast in my oath that I made 56 days ago to support and defend the constitutions of the United States and of Utah. I will carry out my duties with fidelity, transparency, and impartiality, treating every person who appears before me with the dignity and respect they are inherently due because they are human beings. Let me be clear. I will not put my finger on the scale of justice. These proceedings will be open to the public, conducted in accordance with the law, and handled with diligence and competence to ensure that justice is never compromised. It is the standing order of this court that Mr. Robinson shall be allowed to appear in person so he can fully engage with his attorneys and participate in these legal proceedings. Counsel, regardless of who is watching, whether it is the nation or a single individual, we must fulfill our roles with integrity, civility, and diligence. I encourage each of you to give your very best to this case. Neither Mr. Robinson nor the people of Utah deserve anything less than the fair and impartial administration of justice. In regards to the next hearing, counsel, on that October 30th date at 10 a.m., it's the court's intent that be in person if it be the wish of counsel for the defense for Mr. Robinson to be present.
It is, Your Honor. Thank you.
Thank you. Counsel, anything else that we can address today?
Your Honor, we appreciate the court's comments with respect to Your Honor's role in this case. In like matter, we commit to approach this case with integrity, with professionalism and civility. We are truth seekers. We will aggressively pursue the truth in this case. Thank you.
Thank you. All right, counsel, unless there's anything else, thank you for being here. This court is in recess.
As of now, the next critical date is October 30th. That's when the preliminary hearing is scheduled to take place. This time, Tyler Robinson is expected to appear in person, not through a distant video feed. It won't be the full trial, but it will be a decisive moment. The prosecution must present enough evidence to convince the court that the case should move forward to trial. For the first time, the public will likely hear a more detailed account of what investigators believe happened, how the assassination of Charlie Kirk was allegedly planned, how it was carried out. It's the stage where speculation may finally give way to facts, where the nation begins to see what the case truly rests upon. The path to justice is rarely as fast as the headlines. It moves slowly, step by step, through hearings, motions, and testimony. But every step matters. Every question asked in that courtroom, every answer given under oath. We'll keep following this case as it unfolds, fact by fact, moment by moment, because the search for truth is never a straight line. If you want to stay with us through every new twist, like this video, subscribe to Unraveled Crime, turn on notifications, and share your thoughts in the comments below. Your voice matters. Justice needs witnesses. Stay curious, stay vigilant, and stay with us, because the next chapter in this story could change everything.